Welcome to Senate Corporations. Roll call, please.
Senator Boner.
Here.
Senator Case.
Present.
Senator Nethercott.
Excused.
Senator Scott.
Excused.
And Chairman Driscoll.
Here. Okay, first announcement I'll make is House Bill 38, for anybody that's out in the waiting room or anything, is going to be laid back till Tuesday. We had someone that couldn't testify. So we will not be working 38, even if we get through House Bill 38, even if we get all the way through. First bill we'll take up is continuation of Senate File 28. And I believe in your folder, we've all got basically a substitute bill or amendment, one or the other, depending on how we want to handle it. We will do. And I know we have Ms. Langford at least in the waiting room. And who else do we have at Julie Freeze is in the waiting room as well, Ms. Freeze. We just let in the clerks into the waiting room, because if we're going to do this, we're just going to kind of start over and work through this substitute, and we'll have them comment kind of at will. It'll be a bit of a hybrid meeting. I see some head shaking. That's all right. Is that all right with you, Senator Case?
Absolutely.
I think it's the only way to handle it with fairly expeditious. So, Mr. Meyer, if you want to come up, and if there's someone else that wants to come present with you, let's see if we can hit a meeting of the minds between the clerks and the bankers and the auto dealers, and see if we can get this done. I would actually do something strange. Senator Case, would you like to kind of run this? You've done this bill, and I think you're actually better to the subject matter than I am to do it. Are you comfortable doing that?
I'm happy to do whatever you wish, Mr. Chairman.
I just think you're better. I know you ran the bill a year ago, and I know you know the people somewhat better. So I'm going to just let you take over and run the meeting.
Okay, Mr. Chairman, how about if we start, we've got the clerks online, and Mr. Meyer's here. I think Mr. Meyer put together the substitute bill. He tried to incorporate everything as the way I understand it, but maybe we could let him present the substitute bill.
Thank you, Mr. Chairman. Senator Case, you do have in there what I tried to do without, I guess, the ability to do the
Is your
numbering on the
microphone on,
side.
Mr. Meyer? Green light?
Yeah, it's on.
Okay.
A substitute bill. The bill that we had worked through on the interim had enough changes that I thought that this would probably be a little bit better. So it takes everything from the way the statute is now to what we did in interim, plus what we've done with the county clerks over the last few months. It does take it out from a two-step process really into one that has two requirements regarding the financing statement and making sure that there's a properly tendered application along with this financing statement or security agreement that goes with it. And then following the lead from the county clerks, we modified paragraph B to take out the word immediate, so that it does read, upon receiving that information, the county clerk shall process the stuff with the right month, day, and year that it's actually delivered to the county clerk. There's a couple of minor changes in C to talk about that holder of security interest. And again, at the end of subparagraph C talks about when it's properly tendered to the county clerk. So I'm happy to go through any specific changes that you want to talk about, but those are really, the idea is just to make sure that it is effective when it's brought in to the county clerk's office, the title and everything, as long as it's properly brought in. And that was the issue that we were running into, is that whether it's lenders, whether it's automobile dealers, whether it's whoever that's bringing packets in that are not complete, either the VIN number hasn't been checked, they don't have the right fee or whatever. We don't think that that's appropriate to have those have the effective lien on that title. But once all that proper information is there and they have it, they can put a date on that. Then whenever they get to the point of processing, depending on man hours, elections, whatever else is going on in their world, they come back to, we know that it's effective as the date, the paperwork was brought in.
Okay, thank you, Mr. Meyer. Questions for Mr. Meyer? Senator Driscoll.
Senator Case,
Microphone.
can we make sure the clerks have a copy of this? I didn't know if Julie, Mary, do you guys have a copy of this? Okay, that was my only question. I want to make sure you were dealing off the same page we were. So.
I think we should go to them next, if that's all right, if there are no further questions for Mr. Meyer. Mr. Pickard, did you have anything on? Let's go to the clerks. Mary, do we start with you?
Yes, sir. We can start with me. Mr. Chairman and committee, good morning. We're so happy to be here. I am Mary Langford, and I have the honor of representing the Wyoming County Clerks Association. With me today at the table will be the Honorable Julie Freeze, Fremont County Clerk. Our testimony is very short. We really appreciate the work that Mr. Meyer has done on this and has compiled all of our concerns into one bill. As you probably know, our concern has been with Section B, and that has been addressed. We're happy with Section B, and we're happy to stand for any questions. I don't think we have anything else to provide unless if Clerk Freeze would have anything else, but I think we're fine.
Clerk Freeze.
Thank you also for letting us work on this for such a long time. I know it seems like a pretty simple process and we've made it seem pretty hard, but I think the whole idea of us working together was to make sure the bankers got what they needed for their part, but that it worked on this side. And I think the bill we have this morning absolutely does that. And I appreciate the working with everybody on the bill. Thank you so much.
Thank you. And it's good to see you.
You too.
We got a lot of snow here. How much you got?
Not much. Sorry.
Anybody questions for the clerks? Any questions for the clerks? Mr. Pickard, did you have anything to add?
Mr. Chairman, members of the committee, my name is Dave Pickard. I represent the Mountain West Credit Union Association. Appreciate the effort that Mr. Meyer and the clerks have undergone. We've been following the process and support the work that is in front of you today.
Okay.
Stand for any questions.
Any questions for Mr. Pickard? Is there anyone else in the audience or online that would like to address this bill? Anybody in the audience? None in person here. Do we have anybody online? Marcia, are you going to weigh in? We can see you. There you go. Go ahead. Ms. Allen.
Good morning, Mr. Chairman. Marcia Allen with the Wyoming Automobile Dealers Association. I would just echo everything everyone has said. We really appreciate the opportunity to talk again today. The clerks, Mr. Meyer, and working this through and getting it in good shape. We really support it, and I would answer any questions of anyone if they have any.
Thank you. Any questions for Ms. Allen? Thank you, Ms. Allen. Thank you very much. So committee, you've heard the testimony. What is your pleasure?
Move the bill.
A motion by Driscoll. Any amendments? I guess we do this as an amendment.
We'll bring this as a substitute.
Okay.
I think we can do that. So
Yep. So this
this
is
will
what we're
actually
looking-
be, we'll take this to staff. This will become as a substitute bill verbatim as it's written up from the bankers, the way it came. So
That's our plan.
we're going to put a slash by it with clerks. So other than that, it's all the same.
Good. That sounds like a great plan. Should we call the roll on this? Well,
This will be a substitute bill, not an amendment.
so we're kind of voting on the amendment is the vote on the bill is the way this works.
It's a lot easier. An amendment will be all tracked up when they see it. This
Yeah.
makes it a lot simpler.
So we're just going to vote once, but it's on this.
Senator Boner. Senator Case.
Aye.
Senator Nethercott is excused. Do you want to hold this?
We will hold the vote open.
Okay. Senator Scott, hold it open. Chairman Driscoll.
Aye.
So the Senate File 28, the substitute bill, has passed with 3 ayes and 2 open votes.
You got the helm, sir.
Very good. Thank you very much. Thank you, Senator Case, for your past work on it, and particularly Scott and Dave, everybody getting together with the clerks. Been a bit of a rocky road, but we're there, and we appreciate everybody. I'm glad not to ever see this again. So
Thank you, Mr. Chairman.
I'd like to do a quick recognition. We have the first female chairman of the Weston County Commission, Marty Ertman, in the back of the room. After 100 years, having the first female chair is kind of an interesting thing. So welcome, Marty. You're outed. I don't have my order. I hope it's in order. Next bill will be House Bill 91, removal of unenforceable property covenants. Representative Duncan, welcome. Tried to flag you down the garage this morning to make sure you were coming, but.
Thank you, Mr. Chairman. Hadn't had any coffee yet, so bear with me.
You want some?
Would you like a cup?
I'm good.
Okay.
Ready? I think I'll share with you, if you're ready, I'll share with you why this bill came to start with before we walk through the bill. Several years ago, I'm bummed Senator Nethercott's not here to share in this, but several years ago, quite a few years ago, I was sitting at a closing table and covenants came across, as they always do at the closing table. And to my horrification, my clients are made to sit and read these covenants and then initial them. And the covenants basically in Torrington, Wyoming, read that people of color have to enter from the back of the house as a servant and must leave the neighborhood by dark. And this is in 2000 and I don't know, probably 2008-ish. And so they are unenforceable, but they were made to initial them. And so we're all kind of sitting there looking at each other, horrified, like, wow. We continue on. So then I asked the city council, gosh, what do we do about this? This is terrible. Everybody's agreed. This is terrible. Oh, this is terrible. There's nothing we can do. They're unenforceable. So here we are in 2021. This started a little while ago. This bill came to us, the idea, and Senator Nethercott and myself. And so that's where this started. So walking you through the bill, this bill provides procedures for removing unenforceable restrictive covenants for real property that provides immunity from civil liability for those property owners who exercise their rights under this legislation. Starting on page 2, lines 4 through 12, it spells out that any person or representative of an owner, such as an attorney or title company, may record a new instrument that will remove any restrictive covenants that are defined in lines 14 through 19, which are either unenforceable via the U.S. or Wyoming Supreme Court ruling, or is in direct violation of the Wyoming Fair Housing Act, which is identical to the Federal Fair Housing Act. Lines 21 through 23 is the immunity from civil liability if the person is acting in good faith. Page 3, lines 1 through 12 specify who is not immune to the civil liability. And that would be first someone representing or attempting to represent that these covenants are valid and enforceable, or someone who honors or attempts to exercise the enforcement of these unenforceable and prohibited by law covenants. Lines 14 through 23 and continuing over to lines 2 on page 4. That requires a statement on the document confirming that the covenants are unenforceable and are in violation of both the federal and state fair housing laws. The standing committee amendment starting on page 3, lines 16 in the engrossed copy, after conveyance inserts which violates Wyoming statute 40-26-103 through 40-26 through 109. This is basically, which is the Wyoming Fair Housing Act. This amendment clarified that not every document sent for recording has to have the statement on the cover page, just those documents that have the unenforceable restrictive covenants. This came from the title offices. They felt like this made sure that not every single document, they wanted to make sure that that was clear. Page 4 outlines the process for the filing of the new instrument and what must be included. Lines 16 through 20 and continuing over onto page 5, lines 1 through 17. It must include the title of the instrument, which had the restrictive covenants such as, for example, Happy Hollows Homeowners Association covenants, the name and the mailing address of the person filing the new one, the name and mailing address of the owner, the legal description of the property, and a clear reference as to what is being stricken. On page 5, lines 19 through the end of the bill, page 7, lines through lines 13 of your engrossed copy. Now this, I had to tease our new representative, Crago. He doubled the size of my bill, but this is his amendment. And what this is simply prevents the abuse of the statute for illegitimate reasons. Him and Representative Stith both have clients who would really take advantage of this. So they convinced me that this was an okay thing. So that's the end of the bill. That's what this part is. And to clear this up, like I told you before, why this bill has come, after going to the city council, asking what can we do, trying to do a proclamation, and then after conversations with why this bill came about, and Senator Nethercott reminded me that when we started on this bill, that being a legislator, we make the laws, so we can make this change. So that's why we're here. So I stand for any questions.
Well done. Questions for Representative Duncan? No questions? Must have been a great job. Thank you.
Thank you. It's just a great bill.
I agree. My name's on it. Any further testimony in the audience? Come forward, please. Welcome.
Good morning, Mr. Chairman and members of this committee. My name is Sarah Pruis, and I'm a private citizen here in Cheyenne. And I've actually been working diligently for almost a year to find support for the statute on my own time. So my story is in 2016, my wife and I, along with our 5 kiddos, moved from Laramie to Cheyenne so that my wife could pursue a full-time job in the Wyoming Air National Guard. We landed in the historic avenues where we still live. And of course, buying a home is super stressful time. You're selling, moving, hoping, crossing your fingers. So we're sitting there signing for the purchase, and I don't know why it caught my eye, but I saw one of these racially restrictive covenants in our actual deed. Mine said, "No one that is not of the Caucasian race may own this home." I was mortified and disturbed. What was I being asked to sign? We had to initial this page. We were quickly reassured that this was simply part of an original historic document, and legally these all go with the home. We had to sign, but not to worry. Because of the Fair Housing Act, this type of clause is unenforceable. And to be honest, we were Caucasian. We needed this house, obviously, so we signed. But my mind went to the Latinx military family that was selling us this home. Had they happened to see this? Did they have to sign this? Did they then worry about what kind of neighborhood they were moving into, knowing their neighbors had all signed this as well? This nagged at me for years, but last year I started digging. Our racially restrictive covenant is buried right in the middle of our deed, so it's not even like a neighborhood covenant. I quickly learned that while these types of restrictive covenants are still common across the US, getting to the bottom of these was an endless rabbit hole. There was no one really in charge of this. Lots of people don't know them. Who could help me get them removed? I'd spent a few months of research and spinning my wheels, and I finally hired my own private lawyer, Crystal Stewart. One of the first things she did was try to lay out a legal path forward if I were to try to just get it off my own deed. I learned that I could go through the court system to do this. It would cost between $10,000 to $20,000. I'd also have to file a court action, serve every single homeowner in my neighborhood, and then attend a hearing on the matter to see if I could actually get the restriction removed. Obviously, this method is pretty cost prohibitive. And I've spent quite a bit of money on my own actually trying to get to this point anyway, but I couldn't fathom making that type of investment when it would only affect my one property. My goal is not to ease my guilty conscience for signing something like that or to distance myself, but I really want a broad, effective solution that we can just get rid of these in Wyoming. I've learned that this is an issue not unique to Wyoming, but I've learned that there's been 6 to 8 states now that have gotten them removed over time. Ours is probably the most straightforward and simple and the most effective that I've seen. There are several different variations like was just mentioned, but one that I've also come across is no Negro is ever allowed to rent, own, or occupy this unless they're domestic servants. I've learned a lot on this journey and it's not pretty. While these are no longer enforceable, it's true, and hopefully rarely used, they do undoubtedly continue to shape neighborhoods in every city in the US, including Cheyenne and other Wyoming cities. Can you imagine coming across this clause in a home you've just sat down to buy? Or why you might want to avoid these types of neighborhoods if you're a person of color? Or even worse, find out that you've initialed this page without even knowing you have. This is an unfortunate reality that many of my friends have discovered. This is a really easy thing for us to do. It takes little effort and really no cost to right this wrong. We can effect some change with a very simple statute. You know, I don't really care how unenforceable this clause is. What I care about that is no one should ever have to see it going forward put in their face. I care that it continues to restrict neighborhood diversity, even in Wyoming, and I care that it hasn't been dealt with already. The fact is, we don't want it in there anymore, and this isn't about erasing history, our statute. It's gonna still stay in the original documents. We're just not shoving it in people's faces anymore. I liken it to removing stores signs that say whites only. That would be just laughable to have a store being like, well, this is historic. I can have a whites only sign. But you know, I can't enforce it. So don't worry, it's not really a real thing. So I just challenge everyone here to pass this. And the question is not, should we take these out, but what's the best way? And to quote my friend, Pastor Fred Gallup, a Black chaplain in the US Air Force, says, it's wild to me that this is even needed. Just simply remove the language. Thank you for your time.
Questions?
Thank you.
Thank you. Always fun to see citizens show up. Appreciate it. Do we have anyone in the waiting room on this bill?
Yes, Mr. Chairman, and Miss Lori's been admitted.
Welcome, Ms. Urberkite.
Good morning, Mr. Chairman, members of the committee, Lori Urberkite representing the Wyoming Realtors. I wanted to give you just a real quick brief history on how these things happened, why they're there, why they're still there, and let you know that the Wyoming Realtors are 100% behind this bill. When Sarah presented this concern of hers to our Cheyenne Board of Realtors, they invited me to sit in on the presentation. And I immediately said, oh yeah, the Wyoming Realtors will back this, will be supportive of this. It is absolutely our core principles to have housing for all. So how this all started was it back in 1917, prior to 1917, municipalities back east were basically redlining neighborhoods, areas by zoning ordinances. And in 1917, the Supreme Court ruled that in Buchanan versus Worley, that they couldn't do that, that it was not, the municipalities could not do that. It was a violation of the 14th Amendment's Due Protection Clause. So then the neighborhood folks just kind of did it on their own. And so they had their own personal agreements and started writing them in covenant. Since it no longer was legal to do it via zoning ordinances, they took it privately. And then in 1948, the United States Supreme Court ruled in Shelley versus Kramer that racially restrictive covenants were unenforceable. They didn't say they were illegal. You could still write them if you wanted to. It was a private agreement between private individuals, but they were unenforceable in state courts. So then they continued, even though they were unenforceable. It was kind of a way of discouraging the wrong kind of people to live in a neighborhood. And in fact, the lending institutions, the federal HUD actually applauded these covenants, saying it was a good way to keep the wrong kind of people out of good neighborhoods. So there was a lot of redlining going on, and discriminatory covenants continued, even though they were unenforceable. Then in 1968, Title VIII of the Civil Rights Act passed, the Fair Housing Act, and it prohibits the discrimination of direct providers of housing, landlords, real estate companies, as well as municipalities, banks, and other lending institutions, including homeowners insurance companies, from discriminatory activity. This made it illegal to even write those things. So that ended the ongoing addition to covenants, but it did not erase what was already there. So there are still racially restrictive covenants in the chain of title on properties all across the United States. Wyoming is absolutely no exception, as you've heard. There are racially restrictive covenants right here in Wyoming. They are unenforceable, they are embarrassing, they're discriminatory, and yet they exist. So the bill creates a method to have those removed from the ongoing chain. It does not erase historic documents, but ends the perpetuation of racial discriminatory verbiage in our land records. And I will say that we plagiarized this bill somewhat from the Virginia statute. They were one of the first states to pass it. Texas, Ohio, and South Carolina are all moving forward with legislation as well, along with several other states. And Wyoming will be in one of the first. I mean, we're not the first because Virginia passed it already, but we certainly will be stepping out ahead of the rest of the pack in righting these wrongs. I also want to let you know that we have had conversations with the president of the Wyoming Realtors and the executive committee. Wyoming Realtors provide our members with forms that are pre-approved by, or that are written and approved by our legal counsel. And we will be providing our members with a one-page simple document that they can use at closing, that they can provide to the title companies to move this forward and to it be like a certificate of release. So we are 100% behind the bill, and we thank you very much for your time, and I'd be happy to answer any questions.
Questions from Ms. Eberkeit? Thank you very much.
Thank you.
Do we have anyone else in the waiting room?
Mr. Chairman, we don't have anyone with their hand raised at the moment.
Last chance. If anyone's there, raise your hand. Anyone else in the audience? Come forward. Welcome.
Thank you. It's so nice to see everybody. You wear glasses and you look through two.
Like headache.
This is nice.
Mr. Chairman, Committee, my name is Dale Steenbergen. I'm President, CEO of the Greater Cheyenne Chamber of Commerce. We also run the Wyoming Business and Industry Federation, which represents chambers all over the state of Wyoming. I think we have about 5,000 businesses under our umbrella right now. So we support this bill. We think it's important as we move forward as a state. We talk about economic development in this state all the time. And we talk about taxes and we talk about all these other rules, but yet we don't ask CEOs what they're looking for. And what they've been looking for since 1991, number one or number two on their list is labor. And what do we know about young labor? They want to live in places with communities that are varied, with people of many colors, many cultures. They enjoy it, they want it, and yet we don't address those. So to me, this is an economic development issue, because this starts placing Wyoming as a state that is welcoming to folks of all different backgrounds, all different colors, truly living up to that meaning of the equality state. The other reason we support this is last summer, General Ray from Global Strike Command called all of his civilian leaders together from every base that he manages and said, you guys need to start watching these kinds of issues in your community. Well, in Cheyenne here in the state of Wyoming, we have a $93 billion project, which is up to about $105 billion now because of inflation at risk, right? We're first off, we've done our work, but I think it's important that we try to meet some of those needs and realize the importance of this. Now, the pushback always is, it's not enforceable anymore. It takes a little paperwork to get it done. So my first call was to my friend Leonardo, who is a Black Chamber executive outside of Washington, D.C. And he's a little bit of a smarty pants, but I said, why is this important? He said, well, I'm going to tell you why it's important. He said, I'm buying a house in Wyoming and I sit down and read this and with my son, who's a teenager, and he said, here's what I tell him. He said, well, this writing was in here because Black people didn't used to be as important as white people. And he said, they leave it in there just to remind us that every so often we kind of need to be put in our place. Right? This is not what we want folks to think of our state. This is a pretty simple fix. If it's important to others, we should be respectful of that. Let's get this taken care of, get it moved down the line, and show that we are welcoming to people of all different cultures, all different colors, and we truly live up to the meaning of the equality state, and that is something to celebrate. Thank you, Mr. Chairman and committee. I'd answer any questions.
President Steenbergen. See none, thank you. Last chance for public comment. Public comments closed. Committee, what's your pleasure?
Move the bill.
Bill has been moved. Discussion on the bill. Question on the bill. Roll call.
Senator Bonner. Aye. Senator Case.
Aye.
Senator Nethercott. Aye. Senator Scott.
Aye.
And Chairman Driscoll.
Aye.
Mr. Chairman, House Bill 91 passes with 5 ayes.
Good job, Representative Duncan. Good bill. Thank you.
Appreciate it.
Next up, we have House Bill 7, Air Ambulance Membership Organization Regulation. It's a bit of a redo, a little bit thicker bill than last time. Who do we have to present? It's probably going to end.
It's a Minerals Committee bill.
So do we want to lay back or do we want to go ahead and go through it? I think we're pretty familiar with it as a whole.
Mr. Chairman, I would kill the bill, but I think that would be
You're not going to do that.
Problematic.
You're not chair today.
so. I would say let's work the bill. We are familiar with the issue. Senator Case obviously sponsored a very similar bill.
That was my thought of Senator Case. Would like to.
Half the loaf's better than none. Let's go for this bill.
Okay. So you want to work us through it real quick, Senator Case? Or do we want to see if we got other testimony right off the bat?
Why don't we do that?
Okay, do we have any testimony in the audience for it? So we may flesh some out on it. I think everybody's somewhat familiar with the bill. It's out of the House, so.
Mr. Chairman, we have about 3 that I'm admitting right now if they just turn on their video.
Perfect. We'll start right here. We got an old friend here. Mr. Reedman.
Good morning, Mr. Chairman, members of the committee. I'm Jeremiah Reeman here on behalf of the County Commissioners Association. I am joined virtually this morning by Washakie County Commissioner, Mr. Fred Franson, who has a specific background and can share their experience. Mr. Chairman, my members are supportive of this bill. What they have liked is that this bill strikes a balance between correcting the issues that appeared in the legislation of the past couple of years and provide some important consumer protections, because that is a component of this industry that we want to ensure that we reward good actors and protect against those that may inappropriately enter into this space. Mr. Chairman, I would actually want to defer the rest of my comments and allow Mr. Franson to take it from here and again, share his experience, but we're happy both to take questions on the bill.
Thank you, Mr. Reedman. We'll have you stay where you're at. Mr. Cranston, you have the floor if you would like to proceed.
Good morning, Chairman Driscoll and the members of the committee. My name is Fred Franson, and I'm one of the 3 Washakie County Commissioners. I'm here to strongly support the Air Ambulance Membership Organization, House Bill 7, and to thank you for bringing this very important issue forward so that we can discuss this here. Washakie County has had an air ambulance life-flight membership for all of Washakie County residents since 2015. But before I go on, I'd like to share just a little bit of personal information. 4 weeks ago, I had an elderly lady come into my office and show me a bill that she had gotten from our life flight provider by accident. A simple phone call and the bill was dismissed by marked membership covered. Unfortunately, I was not able to keep my 6-foot distance at that time because she ran over and gave me a great big hug on that and thanked me profusely. The county's Life Flight membership has saved our residents thousands of dollars by having no out-of-pocket expenses, and that membership has also saved lives by providing an essential service for our residents. This bill will afford Wyoming residents an opportunity to continue or enter into a Life Flight membership while providing consumer protection. Without the passage of this bill, it will diminish that opportunity and any consumer protection. This regulation is a regulation light, and it removes the air ambulance transport service providers from the disability insurance definition and establishes an air ambulance registration requirements and regulatory standards. With that, Mr. Chairman, I would stand for questions.
Any questions for Mr. Cranston? Seeing none, thank you. Good job. Mr. Rood, would you like to go next?
Yes, Mr. Chairman, thank you. Committee members, Mr. Chairman, I'm Jeff Rood, the Insurance Commissioner. As you've heard, currently as the law stands, if you have an air ambulance membership, it's required to be licensed as a disability insurer, and that is a difficult process. It is not easy. We've only had one company that in fact went through with the process and is licensed. But the good thing about them being licensed is that along came the consumer protections. House Bill 7 does away with the license requirement. So the company selling the memberships must register though. And this is much easier and much more manageable. And it actually mirrors what's done in Nebraska. And that's important because many of the companies that fly and offer this service in Nebraska will also do it here. And so it's not that arduous for them to really sign up and register. And then there are a list of consumer protections that are in the bill. I think this is an improvement, and I think there's a protection for consumers. Unfortunately, there was a number of amendments on the bill, and they changed some of the consumer protections, and I'd like to just touch on one or two of those. It changed the notice requirements to the consumers, and it changed the financial reporting requirements. I understand there's going to be a couple of amendments brought, one by AARP, and I think Senator Nethercutt also has them. I've looked at both of them and we think they're appropriate. We think they're good. I still wanted to address our main concern, the one that jumped out to me the most. We'd received numerous calls. 80% of the calls we received were from senior citizens. And most of the complaints we've actually had filed with us were from senior citizens who attended the free lunch presentations by someone selling the memberships. And they described them somewhat as a high pressure sales pitch. And in fact, we actually had one of our members from our office attend one of these seminars. And he came back and he said, yeah, some of the things that are said, they're a little bit fast and loose with the facts and whatnot. And there was some concern there. The bill as drafted right now, that's before you. If you look on page 20, line 16, all the way through page 22, line 15, are all the disclaimers. This is what we want to have consumers understand. We want them to know this information before they make a choice. But as the bill is written now, these disclaimers only have to be mailed to consumers 5 days after a contract is signed. Now, for me, that's troubling in a number of ways. I mean, theoretically, we could have a salesman say several things. They might be accurate, they might be misleading, they might be somewhere in between. But a member's not going to, the consumer's not going to have that information in front of them to make that choice ahead of that notification. And I'm afraid that if they come to our office, enough time may have transpired where they don't have recourse to get out of the contract within 30 days. And I think there's also a problem with, let me see here. Oh, that if they do file a formal complaint, we'll get involved, they'll talk to a consumer representative and we'll contact the company. Well, what I would expect the company to say is, well, we've done our due diligence. We sent you the notification 5 days after you signed the contract. We are not at fault for anything that might have been said or done there. All I think we ought to do is bring back in those disclaimers so these individuals have the information ahead of time before making the decision. So with that, I'll be happy to answer any questions. I'll stand by if there's other questions when the amendments are brought up.
Questions for Commissioner Rood? Senator Scott.
Mr. Chairman, looking on page 7, a provision starts up at the top of the page, subsection B there, and it lists a number of reasons where the insurance department may suspend or revoke a certificate of registration after notice. And there's a series of points that would be cause. And particularly I'm looking at 2 little I on line 11 and 3 little I on line 15. My question to the insurance department is, do those provisions give you adequate authority to suspend or revoke an outfit that is engaged in deceptive marketing practices, that is using inappropriate high pressure tactics or selling Medicare recipients policies they can't use or anything like that? Is that authority adequate, Mr. Commissioner?
Can I follow up?
Follow up first by Senator Nethercott, and then we'll go back to Commissioner Rood.
Thank you. Following up with Senator Scott's question on this particular point, I understand, Mr. Rood, that this language really comes from the Consumer Protection Act. What is deceptive, misleading, or unfair practices? Would it be helpful, do you think, if we reference that particular act, which is another statutory section, of course, but to reference the act in total to provide those definitions and further guidance? Because I think that's the source of that provision, but curious to hear your thoughts.
Commissioner Rood.
Mr. Chairman, Senator Nethercutt, Senator Scott, it would. It certainly, would spell things out a little clearer. The difficult part with the lunch seminars is, unless it's recorded, we don't know what's said. And so we think it's important for the consumers to have all the information up front before they sign on the dotted line. Under the bill, we have the opportunity to look at the advertisements. We would ask for their slide deck to see what they showed, but I can't know what was said. And sometimes it's the company would say, or the individual would say, well, senior citizen Smith thought she heard this, but in reality, that's not what I said. And that's what's most troubling to me. But the short answer is yes, it would help. It really would if we referenced it for Trade Practice Act, we brought it back into the bill.
Thank you. Further questions, committee? Okay, we'll go to Mr. Laycock next. Welcome, Mr. Laycock.
Thank you, Chairman Driscoll, members of the committee. I'm Tom Laycock, the Associate State Director for Advocacy and Communications at AARP Wyoming. AARP Wyoming is a nonprofit, nonpartisan membership organization for those 50 and over in Wyoming, and we represent senior citizen Smith. Our interest in the bill is involving some basic consumer protections, which already live in the bill, although the timeline for delivering those protections is of concern, as Mr. Rood just mentioned. Today, we hope to offer a very simple amendment to address that issue. So I'm glad to see this bill came back before the Senate Corporations Committee. You folks did a great job of discussing the issue earlier this month. 2 weeks ago, during a committee meeting, AARP Wyoming asked for 2 disclaimers in Senate File 46. Both of those disclosures actually exist in the bill before you today. The first requires those selling air ambulance memberships to let their prospective clients know Medicare beneficiaries already have some insurance coverage on air ambulance rides. The second disclaimer just lets prospective clients know that the company they're buying membership through may not be the one they fly with. However, an amendment entered during the House committee process would require those disclosures or disclaimers be made to clients 5 days after the sale of an air ambulance membership. Small change on page 20, line 11, that would remove a line requiring membership companies. These memberships are generally purchased. The first is the free lunch that was discussed. That does come with a member. That generally happens when someone finds a membership they like online or hears about an attractive membership from a friend, places a call to the membership company, and the sales process starts there. Now, I certainly understand there's some concern about requiring companies to share disclosures during the sales process. Is it sort of getting in the way of the process itself? Although, you know, I think I want to say is just understand we aren't suggesting our members couldn't benefit from a membership. It just depends on their the way they live their life, how they do things that they do. And
are those disclosures, in your judgment, adequate if we fix the problem of the 5 days?
Mr. Chairman, Senator Scott, yes, we believe so.
Further questions for Mr. Laycock? Thank you. Mr. Kilman Burnham, I hope I did.
This bill as it is with the amendments. We are excited of cooperation with the state and Mr. Rood's office. We feel things are going well. Yesterday, because the 8th Circuit Court issued its long-awaited ruling on a North Dakota Senate Bill 2231 that was passed in to air ambulance in states like North Dakota, and they can't use the insurance codes to regulate air ambulances. But we want to move the way we are now because we feel that it's working well. Everyone's been fair. We've also talked to Mr. Rood and also talked about a bond with this. And we're just thankful that all the work that's gone into this bill, and Rep. Bear, who has been moving things along, has been amazing to work with. Not only that, but he's pretty stern and focused, but he's very fair. And that's what we are most concerned about, is making sure that everyone in Wyoming feels like this bill is a fair bill and gets what everyone wants out of it. So thank you very much, Mr. Chairman.
Mr. Kilman Burnham, who are you with?
I'm with AirMed Care Network, the parent company, Global Medical Response.
Very good, thank you.
Sorry,
Question?
sir.
And Mr. Chairman,
Case.
is that an ambulance air provider or is that an insurance company or what are you?
We are the parent company of AirMed Care Network, and we're the company that provides the service for like the County Commissioner Langston in his area.
All right, thank you.
Further questions? Further questions? Thank you. Do we have anyone else in the waiting room? Senator Scott?
Mr. Chairman, a comment if we don't have anybody else.
I've got a question before. And it may go to the lawyers in the crowd here. Can counties or county hospitals ask for specific services? So if a county's got a contract with one, can they ask?
Mr. Chairman, the answer to that question based on testimony in Committee 10 last year or the year before was that typically when the county hospital is sending somebody out by air, they use the
Thanks, Senator Scott. I guess from my end, though, I'm a little different is if a whole county's done it, because if we're looking at counties, obviously you want to be covered if you're one of the citizens in that county. And I just wanted to know the legality because I think it has great interest up in our country if you knew you were going to get it. But if there's 3 providers and it's a 1 in 3 chance, it changes a little bit on a county commission decision, whether they pull the trigger or not. I guess, Mr. Cranston, do you guys do any way to do preference on it?
Mr. Chairman, with our county hospital that we have here, it is we have a provider that has leased that hospital from us. And ultimately it is up to the doctors of whether or not they're going to call a life flight. And it's the best life flight that's going to be available. In this case here, we do have our life flight provider that has a station here in Worland. There's one in Park County. There's 2 in Fremont County, and there is one in Campbell County. that they have availability to have, Life Flight come in and come in if they're busy with another flight on that there. So they have a good provider on that there. The other Life Flights that are available would be out of Billings or out of Casper. It is just depends on how many Life Flights are in the air, helping out folks on that there. But really, to answer your question on that there, it is going to be up to the doctor whether there's going to be a Life Flight. With ours, it's very handy because it's just a matter of just a couple of, maybe about 4 or 5 minutes, and the Life Flight is on the way. So that's the biggest thing is what it is, Mr. Chairman.
Great. Thank you very much. Senator Scott?
Mr. Chairman, what Senator Baldwin said on that, and he was often the one at his hospital that was actually calling the air ambulance, was that where they didn't have one that had been dictated by the receiving hospital, they would call the one that was most available, and that he did not know if the patient had air ambulance coverage with anybody when he did that.
Perfect. Thank you. Further questions? Okay, we've got one more in the room, and I don't have his name and my eyes aren't good enough, so I'll ask you to introduce yourself and
Mr. Chairman, can we get the mic on?
Okay, I'm sorry. Mr. Chairman, Doug McMillan, CEO at Cody Regional Health, Cody, Wyoming. I apologize for that, members of the committee. I appreciate the opportunity to make a few comments regarding House Bill 007. I've been the CEO at Cody Regional Health for 24 years, and the time I've been here, when I started, Wyoming really only had one air ambulance at Wyoming Medical Center that everyone around the state utilized. Those of us on the edges of the state in Montana, South Dakota, Colorado, Utah benefited from those air ambulance services closest to us. I've experienced numerous air ambulance companies come and go in Park County over the last many years. The membership that this bill talks about to reinstate benefits many around the state and has, which I understand. But my comments, I want to address my concerns, the way the bill is structured. And again, specifically regarding the memberships. The biggest concern I have that's been stated previously is, yes, the physicians are the ones that make that call, but the physicians don't know what air ambulance is available. There's many times the individuals that have a membership that air ambulance is not available and end up having to pay for another air ambulance that flies them. And again, I know that previously we talked about, or I heard testimony regarding the disclaimers, availability, but that is a big issue. One of the other major concerns that I would like to address is the way the bill is structured that I think needs more comments and time to address is the appropriateness of transfers. We have seen in the Bighorn Basin patients being transferred through memberships that should not be transferred. They're not medically appropriate, medically necessary to be transferred via air ambulance, but it's easy to transfer these patients. Again, the good thing is it doesn't cost the members anything, assuming that they get the air ambulance that they have a membership with. And then we can go on and on regarding the issues regarding the cost, balance billing, dependent upon the company, the air ambulance involved, what can be charged, what can be balance billed. And again, last year I was appreciative of the work that Senator Scott did in helping essentially take away the ability for air ambulances to have memberships. In Park County, since that has happened, we are working with MASA, which again, I think many around the state are working with. It's not a membership driven service. It's more, it is somewhat versus insurance. It's an insurance service, but it provides benefits for ground and air. And I guess another point I want to address is I've provided earlier testimony regarding ground ambulances in Wyoming across the US and providing more funding for ground ambulances. I think these memberships are going to continue to take away a lot of community ground ambulances that every community relies on. I think the communities need ground ambulance before they need air ambulance. And again, with the inappropriateness of a lot of these transfers occurring, I think we're going to see a lot more ground ambulances go away that no longer can be supported. We've seen several in Wyoming. We're talking to other communities right now that have reached out, expressed for support to assist them in their ground ambulance. Cody Regional Health has paramedic-based EMS ground ambulance services. And as we've looked at a lot of the numbers of these air flights that are occurring in the basin, majority of those should be and can be transferred via ground. With that, my concerns are the way the bill is structured. Number one, biggest concern is the appropriateness of individuals being flown that have memberships with these companies. So with that, I appreciate the opportunity to testify, and I'd be happy to address any questions.
Mr. Chairman, it seems that we've lost audio in the meeting room. Mr. Chairman, if Judy can unmute the Senate Corporation Zoom on the RAC PC, we have Clarissa coming into the room for help if needed.
Go. There, she got it.
Can you hear us now?
All right.
All right. you're back.
Perfect. Thank you so much, Mr. Chairman.
Proceed, Mr. Michael.
Third time's a charm, right?
You know, you may not make it today. We're going to give you one more try. So.
I'm Matt Michaeli with Air Methods, and here to testify in support of this legislation. And we've heard lots of good testimony. We, as Commissioner Rood alluded to, we work closely with them, with the Department of Insurance, and with the AARP. We share those concerns over consumer protection. We think that as we just heard, this is a complicated issue. There's lots of things that are at stake here, and we think the consumer protection piece of this is very important. We certainly support the notice provisions that we've heard from AARP and ask for that amendment to be moved forward. We also, the one that I wanted to focus on mostly is the financial stability of these companies. And as the bill was originally drafted, there was provisions in there that required that if you're going to sell these type of memberships, you have to prove to the Commission, Department of Insurance, that you're financially able to meet the commitments that you're making. We feel that some of the amendments that came out of the House watered that down to the point where it no longer really provides that a company has to be financially able to meet these commitments. And so we've worked with some amendments, and we've worked with Senator Nethercott and with the Department of Insurance to try to fix that. And they're simple, very simple amendments to add, basically it just says that they have to be able to show that they're financially responsible. We think that that's a bare minimum, that you should be able to, if you're going to go out and you're going to sell these, and especially as we've heard, if these are happening at senior citizens homes with people that maybe don't have as much information as they should, we want to make sure that the company selling it has the financial wherewithal to meet the commitments that they're making. And I'll defer to Commissioner Rood on this, but certainly the amendments that we've put together, we've ran past them, and they have the expertise and the ability to look at this and to make sure that these companies, and I think it's self-explanatory. You don't want somebody, selling these out of the back of a pickup and pocketing the money, and then, even with the $200,000 bond in place, that's 6-7 flights and it's gone. And we just want to make sure that whoever's selling this is a real company that's here, that really has the wherewithal to follow through with the promises that they're making. So with that, I'll stand for any questions.
Questions?
Yes,
Michael,
Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. Mr. Michael, I thank you for being here. And, of note is this Eighth Circuit opinion that came out yesterday. Have you had an opportunity to review that opinion?
I did. And like you said, it came yesterday. So I read it last night and I looked at it this morning again. I do think that, as we heard from the other air ambulance company, it's not really applicable to this piece of legislation. First, I would say that the obvious, it's the Eighth Circuit, and we're not in the Eighth Circuit, and it's a first impression legislation. Decision. I'm not sure other courts are really going to follow that path. But more importantly, what happened in North Dakota was a complete ban on memberships, and that's not what we're doing here. There's nothing in that opinion that I think says you can't, make sure that these companies are providing information and make sure that these companies have the financial wherewithal, which is really what this legislation does.
Thank you. Further questions, Mr. Michael? Senator Scott, your mic's on.
Mr. Chairman, would that opinion interfere with any ability of ours to deal with the problem of you've got a membership in one company, but that's not the one that comes, and therefore your membership didn't do you any good?
I don't think that opinion would address that question. As I read the opinion, again, admittedly, quickly, was that if you passed a law that said you could not have any memberships at all, then that would be problematic under that decision.
Senator Nethercott.
Thank you, Mr. Chairman. I do think we need to study the opinion more carefully. I do think we need to understand whether or not the opinion indicates that the Department of Insurance does not have regulatory authority over these types of companies. And if so, how potentially we can address that. I do think there's legitimate concerns over the ability of these companies. It's curious to me that the other air ambulance service provider, despite others' opinion of that law, wants to move forward with creating state law, providing authority to the Department of Insurance when that litigation involved a similar air ambulance company and their Department of Insurance, who had the authority to regulate those companies, and that was found to be unlawful. If you could introduce yourself one more time, I could finish the opinion. But with that, I have grave concerns, and I think it probably could be addressed in the bill, but we may need a little bit of time to work that out. We got to study it carefully.
Mr. Chairman.
Senator Scott.
Senator Nethercott, did you say lawful or unlawful?
It appears that the Eighth Circuit, in reviewing litigation between an air ambulance company and the Department of Insurance of North Dakota, found that North Dakota's ability to regulate the air ambulance company was unlawful. They did not have the statutory authority to do so, and that they were preempted by federal law associated with a federal act that I'm unfamiliar with regulating the air industry.
I think we know the people. We can buy time. We can get this bill. We'll get you time to read it. We're more than capable of amending bills on Or resurrecting
bills, Mr. Chair.
You know, that's called a nesting bill. We'll talk about that later. So we'll proceed on with that in mind, but at least my thoughts are the committee may digress. We're better off moving something forward and having a tool there than having none. So further testimony or questions? Okay, thank you. Do we have any more testimony either online or in the crowd?
Mr. Chairman, I do not have anyone with their hand raised online currently.
Senator Scott.
Mr. Chairman, just to comment on the origin of all of this. What happened was we were seeking to deal with the problems of air ambulance in Committee 10. I forget if it was a committee bill or Representative Barlow's personal bill, but it was seeking to exploit the Medicaid ability to regulate. That the Medicaid folks wouldn't go along with. But as part of that bill, there was a requirement that companies providing these memberships had to register with the insurance department. The intent, as I understood Representative Barlow, and I've assisted him on it on the Senate side, was that we would find out how many were there. And we were aware of the problem of often the company that came was not the one that you had the membership with, and people were getting hurt because of that. And we hoped it would give, the registration would give the insurance department the authority to deal with that problem. Our view was that the registration was a very simple thing, and we expected companies to comply, which they chose not to. They chose to discontinue and institute a campaign for legislative action, repealing it instead. That was a surprise to us. And then in taking all the calls that arose from that, we discovered that they were heavily marketing to senior citizens who basically could not use the product because of the way Medicare was. So that's the history behind this. And Mr. Chairman, I have one further question for the insurance department if they're still available.
Mr. Rude's still online, so
And
go ahead, Senator Scott.
that is, if we pass this bill as it is, will they be able to deal with the problem where individual buys coverage with a membership in one company, but that's
Mr. Chairman, I believe Senate corporations.
We keep freezing up, but we're back again.
So here's the issue. Here's the issue.
Senator Nethercott.
This is the issue. Whether or not the Airline Deregulation Act would preempt this bill, because the Airline Deregulation Act states as follows. I just got kicked off. It states as follows. It expressly preempts states from, quote,
Being froze.
well, the Zoom situation is a nightmare. States from enacting or enforcing a law. It preempts states from enacting or enforcing a law, regulation, or other provision having the force and effect of law related to a price, route, or service of an air carrier. 49 USC Section 4, 417.13. And so that's what the air ambulance provider in North Dakota did to sue the state, saying you don't have the authority to regulate us this way, regardless of it's the Department of Insurance, and the Eighth Circuit agreed. And so I think we have to question based on the Eighth Circuit, and I understand the issue that we're not bound by the Eighth Circuit, but I can't imagine that the Tenth Circuit would reach a different conclusion regarding whether or not the ADA preempts state law. So there may be another way around this, but I do think it requires additional study.
Mr. Chairman, and I certainly agree that that's the issue. My reading of it is that the Eighth Circuit found that prohibiting these types of agreements completely is in fact a regulation of price, right? That you're saying that you can't price it a certain way. I don't read it necessarily. Now, I think it is, we can still talk about it, but I don't read it to be that you can't make them provide information. That you can't say that that the Consumer Protection Act type stuff doesn't apply, or that you're not even allowed to make sure that the person selling this is financially responsible and financially able to fulfill the promises that they're making. So my reading of the Eighth Circuit opinion is, if you're going to get in and you're going to start doing things that impact pricing, yes, it's preempted. And why I think after this decision, a bill that would make these types of agreements so you couldn't do these memberships, I think that would be problematic. I don't think this opinion reaches in to say you can't even make them give notice, you can't even make them prove that they're financial responsibility. I don't think this opinion goes that far.
Non-lawyer agrees. Senator Scott.
Mr. Chairman, one of the possibilities is that if the Eighth Circuit opinion is adopted here, that we'd be all right with existing law, which determines says if you're going to offer this kind of insurance, you've got to register as an insurance company. That's a different matter because there is federal law that allows us to regulate the insurance. So you'd have a dueling federal law.
It's not insurance.
But it is a form of insurance, Mr. Chairman. And I think that's what our attorneys would successfully argue.
Oh, what further questions?
Tangled web we weave.
Further questions? Okay, anyone else waiting in the waiting room or in the audience? Last chance.
And Mr. Chairman?
Senator Case.
One from Mr. Michael. It's kind of ironic that one carrier who he represents is asking for this financial assurance requirement to be put in the law. Probably maybe to give them a competitive position, maybe because they are financially assurable and others aren't. But we are in a very competitive little situation here.
Mr. Chairman, if I may.
Senator Scott.
That may be true, Senator Case, and no doubt competition is part of it, but also is, I think, the credibility of the industry. I do think that what we have seen and what certainly the North Dakota legislature experienced from their constituents was some air ambulance providers that could be considered bad actors, that sold a product that didn't do what the consumer thought it did, to their detriment of tens of thousands of dollars. And so that's concerning. And so when you have a legitimate industry, and I'm not saying which one is which, that is harmful to their own industry when you have bad actors who in a similar business, are not providing the same type of service. So it's protecting everyone through an effort of kind of self-regulation and an agreement to be governed.
Thank you. Senator Scott.
You also have another branch of the industry. I know the company that comes into is largely used in Natrona County, wrote us after the bill passed and said they no longer sold memberships, didn't care to, and they've adopted the strategy of getting in network with the principal insurance providers, meaning that the ones that are left out are those that are either self-insured, either as a business or as an individual. But many of the other people are covered through that method of dealing with the world. So That's another business model that's
This
out
is the
there.
whole models, yeah. Senator's case.
I'd like to follow up on Senator Nethercott's observation. It seems to me that trying to determine financial capabilities of a company at the point of the membership card is kind of maybe a little bit backwards, because we have whole counties that have, entered into agreements with these companies to provide services in their counties and encourage them to come and all that. And if they haven't figured out the financial viability to have good people come provide ambulance services in their counties, how do we expect whether the cards is approved with the financial viability or not? It's just way at the back end of
We're actually
these
on the
decisions.
amendment. Let's go ahead and get through and we'll work. Yeah, I say that's where I'm at. We're actually a little bit ahead, folks. Any more testimony? Any more testimony? Public testimony is closed. We're back on the bill. What's your pleasure? Bill has been moved. Discussion on the bill or amendments? Senator Scott.
I think Senator Nethercott has a couple of amendments as well. I've got two. One of them is on page 7. And it's a technical correction, largely to get us within our drafting standards. On line 12, page 7, delete such. After manner, delete as to, insert that. And on line 13, this misrepresent to misrepresents. Just an S to it. So it would read in a manner that represents its services or capacity for service.
Second, any discussion? All in favor of amendment, raise your hand.
Did Judy get it?
Amendment is passed. I've got a copy for Judy. I can take to her. I'll just
I
give my
like
bill.
suches.
What's that?
I like suches.
Mr. Chairman.
Senator Scott.
On page 20, trying to deal with the insurance department complaint. Starting on line 9, after E, strike when, insert before. On line 11, after mail, insert give, comma, or, comma, with consent of the person, comma, emails. And then it reads to the, and then strike member, insert person, and then strike the within 5 business days of the purchase. Mr. Chairman, that's the amendment. I can read it as it would read with the amendment.
One more time. Are you catching this, Judy?
Yes, if you could read it one more time.
Okay.
Okay, Mr. Chairman, I'll read it as it would read with the amendment. Before, starting on line 9, before a person purchases a membership from the Air Ambulance Membership Organization, the Air Ambulance Membership Organization shall mail, comma, give, or, comma, with consent of the person, comma, email to the person a separate document, etc.
Okay. Did you get that, Judy?
Get it?
Let me read it back, please.
Perfect.
Before a person purchases a membership from an air ambulance membership organization, the air ambulance membership organization shall mail, comma, give, comma, or, comma, with the consent of the person, comma, email a separate document printed in bold to the end of the sentence.
No. Email to the person.
Okay, email, okay, yes, to the person, a separate document.
Okay, committee, do you understand the amendment? Question on the amendment, all in favor, raise your hand.
It's historic.
Aye.
Senator Scott is promoting email. I mean, get your hand up here. With consent, but
Okay, further amendments.
Mr. Chairman.
Senator Nethercott.
Page 7, line 16. After the word practices, add as found in WS 40-12-101 at SEC. The Consumer Protection Act. LSO.
Judy, did you get
Okay.
that?
I only know how to write it in
As found
Latin.
in 40 dash,
Did you quote?
It's the Consumer Protection Act, which is 40-12-101.
do you want Consumer Protection Act in there?
Sure.
Okay.
Okay.
Everyone understand the amendment? Question being called. I'm going to make you new raise your hands because we're actually where people can see us. So all in favor, raise your hand. I know you don't like it. Tough. Amendments passed. Further amendments.
You have to ask for the no's.
Okay, we've got one more. Is no one going to bring it?
There's an amendment, yes, Mr. Chairman. It's been passed out. The committee secretary does have it in advance. It's in your packets. It is the amendment as discussed by the Department of Insurance, by Mr. Michaeli, and I also believe by Mr. Laycock from AARP. It is a lengthy amendment. Has everyone had a chance to review? I provided it to some of you in advance.
We had it in advance and it's actually fairly easy to read.
I would move the amendment.
Okay, amendment's been moved. Discussion.
Mr. Chairman.
Senator Scott.
This was the amendment you just passed.
Correct.
Yeah.
It's a financial obligation.
And the amendment addresses the financial obligations of these medical providers. So having them provide this financial information to the Department of Insurance.
Okay, it's been moved. Discussion. Any further discussion?
Question?
Question called. All in favor, raise your hand. Amendment is passed. Any further amendments? No further amendments. We're back on the bill. Discussion.
Question on the bill.
Roll call.
Senator Boner,
aye.
Senator Case,
Aye.
Senator Nethercott,
Aye.
Senator Scott,
Aye.
Chairman Driscoll.
Aye.
Mr. Chairman, House Bill 8007 engrossed passes as amended.
James Bond Air Ambulance is on to the Senate.
Mr. Chairman.
Senator Scott.
I will say I support this bill now, hope to be able to continue to support it, but if I get convinced that the federal court will rule it unconstitutional, I think we're better off where we are.
I think we'll find out on the
We
floor.
were better off with the other bill.
That's the personal opinion, Senator Case. Okay, next bill is House Bill 29, burial for indigent persons. This corporation's a joint corporations bill, which once again, I was not here on that end of it. Representative Zwanitz are welcome to Senate corporations.
Thank you.
You have the floor and we've got about 20 minutes.
I'll try to make it quick, Senator Driscoll, but thank you, committee, corporations. I would just personally like to say how excited I am to hang out with you all in the interim. With any Senate committee, I think I've lucked out. So I'm super excited. So 29 was an interim corporations bill, which again, I was not on corp the last 2 years, but because it was an issue I brought to the legislature and it's evolved quite a bit from the interim bill. Let me just give you a couple minutes of background and then walk through the bill for you. So about 3 years ago, an increasing problem, we'll call it, between funeral homes, mortuaries, et cetera, in counties on what it costs to bury a person and what happens when a funeral home in some of our smaller counties that may only have one or two just say we're not going to do it. And then a county has to go to another county and pay more money to bury an indigent because under the law right now, counties are responsible. And so you were getting complaints on both sides from the counties and some counties saying, hey, they're trying to charge us too much.
The funeral home service saying, they're not paying us enough. Issue came to the legislature. So last year, or a year and a half ago, we decided on a budget amendment that the best way to solve this issue was through a fee on death certificates. And so that did go in the budget, passed both sides. We had some conversations, as many of you remember. And then our chief executive said that was legislating in the budget and vetoed it. And so your interim committee, corporations committee, took on making this into a bill. Concurrently, the interim appropriations committee had a similar issue with the Department of Family Services on how they were to reimburse recipients for indigent burials for recipients who were on social service programs, primarily Power, and a couple of others. So this all came to a head in the House. We combined both bills into what you see before us with a couple of more amendments. So let me just walk you through real quick, Mr. Chairman. Page 2, the first amendment we made, there was on the top of the page on line 2, when we talk about that commissioners shall provide for the burial or cremation. And so we've actually dealt with the statute a couple times in my tenure, and historically commissioners have not wanted to cremate, right? Because perhaps a family member will come forward at a later date and they didn't want to take that risk. But there was some conversation that in some counties and in some instances, the county commissioners would feel comfortable with cremation. And so we did put that in at the, at least 2 of my committee members in the House, that if the county commissioners chose that option to cremate a body, which is much cheaper than burial, the county commissioners could make that call based on this individual circumstances. Then we went through and reviewed, I think, both sides, and it really was a conversation probably more through DFS, myself, and the County Commissioners Association. And I do apologize, I left the Funeral Service Directors Association out of it, on what it cost really to bury, on average. And so we looked at the numbers provided from all parties, and we set a number of 1,500. And that's not as high as some people want and higher than others do, but that's the number we settled on. So what the bill contemplates is $1,500. And so each county can do a request to DFS on an annual basis for the money up to $1,500 to reimburse them for indigent burials. And then again, they're in 35-1-428 on page 3, this is where we will take that $5 for every death certificate and put it into an account. We're putting it into an account housed in DFS right now that's used for indigent burials for citizens who are on social service programs. DFS at least testified to us in committee that they could do this additional responsibility and reimburse the counties without additional staffing or too much work on their behalf. As you know, we also, if you're an indigent veteran, we pay your expenses to be buried in a veteran cemetery. So that's page 2, and the top of page 3, you'll see that $1,500. Again, on page 3 is that the Department of Health, because Vital Records is housed under the Department of Health. So they're responsible for that extra $5 and then submitting it into that account in 183504. Then one half of that account will go to DFS to be used for social service, indigent burials, and then one half will be available for reimbursement to counties. And then you'll see on page 5, it is all subject to the availability of funds, which was really from the appropriations side, that we assume there will be enough money, but if not, DFS is subject to the availability of funds. I hope I quickly explained that, but be happy to answer further questions. I know there were 4 or 5 people who'd be happy to testify. Hopefully all in agreement on the bill still.
Questions for Chairman Vaughn, sir? Senator Nethercott.
Mr. Chairman, it was the only action I've ever done that was vetoed by the governor. I support the bill so far.
When you're around longer, you'll get a few more of those.
I had a similar
Further
problem
questions?
outside.
Senator Scott.
Mr. Chairman, question for the House. Do you know, is Fremont County still solving its problem by simply using a backhoe uninvited on the state training grounds?
Mr. Chairman, Senator Scott, I believe the County Commissioners Association would be more than happy to answer that question, but I do know that the number of indigent burials is highest in Fremont County. So they do have the greatest need by far, certainly.
Further questions, Chairman Vaughn, sir? Thank you. Further testimony, if we've got to start letting people in the meantime, we'll welcome Mr. Riemann.
Mr. Chairman, members of the committee, I will get to that answer here shortly. Mr. Chairman, I did want to just expand on the governor's veto. He did indicate that he would support, and actually a statement says he suggests that this should come back as a separate bill. So I just want to make it clear that he's not saying that this shouldn't happen. Mr. Chairman, I thought I might just give a little bit more background on the county responsibility. Under Title 18, counties are responsible for covering all non-DFS. So what you're looking at there is all non-power related or other, let me just get it, supplemental security income or Medicaid cases. Counties are responsible for those indigent burials. And it simply states in there that without sufficient means in his own estate or other resources to provide for the burial or cremation. So this question about cremation is one that comes up. There are some counties that have interpreted that the language is broad enough to go and take that step. But I think it is important to provide that clarity in the bill as it is provided. Title 42 is, of course, where the DFS responsibilities come into play. And I'll just note there that the statutory provisions provide that the Department of Family Services, the expense for that department shall not exceed $1,000. So where the county commissioners have no such cap, DFS does. And as I understand it, the department currently has a policy that they limit their expenses to $500. Mr. Chairman, Title 19 is where the counties are responsible for veteran indigent burials. It says that that is to come out of the county general fund. And the only provision that exists relative to the county responsibility in terms of cost is that a county responsibility for transportation is capped at $500 for veterans. Mr. Chairman, I did ask my members, I didn't get response from all of them, but their expenses vary. In some fiscal years, there are no expenses. In others, there are. In fiscal year 20, the high end of the responsibility was $21,000 here in Laramie County. We've got various other sizes of costs and budgets that ultimately exist for this. Mr. Chairman, we are supportive of this bill. We appreciate the good work that we've been able to do with the funeral home directors, with the Department of Family Services, with the House to come to a good compromise approach on this, and would ask for your support for it. Senator Scott, relative to Fremont County, it's my understanding that the county has actually worked with the Department of Health and purchased a plot of land by which they can use for these indigent burials. The specific amount in terms of reimbursement, I don't have that immediately at my fingertips, but it is my understanding that they've got that piece of land, and that was a cooperative effort.
Mr. Chairman,
Senator Case.
on that point, I don't think they actually own the land, but it is an existing cemetery at the Wyoming Life Resource Center. It's not the state training school anymore. It's better that we refer to it to what it is, Wyoming Life Resource Center. And there is a cemetery and the county does use it for indigent burials. I don't believe they own it.
Very good, thank you. Questions? Thank you, Mr. Reeman. Looks like we got Ms. Smith in the waiting room. Director Smith, I'm sorry. Welcome.
Thank you. Good morning, Mr. Chairman and members of the committee. I don't have anything to add other than just appreciating the work with the County Commissioners Association on this. I just am available for questions if you have any, if you want any specific information on the DFS Indigent Burial Program.
Questions for Mr. Smith, Director Smith? Seeing none, thank you. Any further testimony? Come forward, please. Welcome.
Good morning, Mr. Chairman, members of the committee. My name is Kyle Eberkite, here today representing the Wyoming Funeral Directors Association. We're just here to pile on our support. As was mentioned earlier, we've all worked collaboratively on this for the year since we actually did pass it. So, we feel really good about it. And with that, I'll stand for any questions.
Questions? See none. Thank you. Any further testimony? Public testimony is closed. Committee,
Move the bill.
bill's been moved. Discussion on the bill. Question being called. Roll call.
Senator Bonner,
Aye.
Senator Case,
Aye.
Senator Nethercott,
Aye.
Senator Scott,
Aye.
Chairman Driscoll.
Aye.
Mr. Chairman, House Bill 29 passes with 5 ayes.
We are adjourned. Thank you.